I began to undertake representation of people that have had assets seized approximately about 7 years ago. And during that period, I have probably handled through litigation about 20 cases to completion. I think I currently have about 15 pending cases in my office at this time. The process of which that came to me about 7 years ago is because pretty much I'm an attorney that does commercial litigation for a living. I have a lot of experience in civil litigation. I've actually co-authored the most used book by attorneys in California for the purposes of civil procedure. And it came to me referenced because the law was so confusing and difficult to figure out that overwhelmingly the criminal attorneys that were handling the cases have no idea what to do about it. And more particularly when the cases are referred to the federal government for purposes of prosecution, it became virtually impossible for most attorneys to even understand what it was they were walking into. I can tell you that by the time I did my first federal case, I had probably handled 10 to 15 state cases, and the first time that I attempted to figure out how the state regs worked, it took me 2 to 3 weeks of 3 or 4 hours a day just to find the appropriate regulations for the purposes of asset forfeiture. In fact, they're buried in law dealing with admiralty law, and they're even in fact buried in sub-indexes of admiralty law just to find out what it is the processes are. Under federal processes, when you're undertaking purposes of asset forfeiture, unlike California law, where if the sum forfeited is under $25,000 or if over $25,000, deals in one case with clear and convincing evidence and in the other beyond a reasonable doubt. Under federal case, the only thing they have to prove is preponderance of the evidence, and in fact, the only thing that they have to prove by preponderance of evidence is a quote-unquote connection to the money or assets to be forfeited. They have done away with, for purposes of asset forfeiture in the federal law, their basic disclosure rules that exist in normal federal cases. They simply do not exist. They were done away with. In fact, for purposes of federal asset forfeiture, there is no obligation to make those disclosures, and more than that, there's a stay. The normal process is that there's no ability for anyone to do discovery in a federal case until it reaches a certain part in the case. However, the federal government is allowed to immediately move forward to engage in discovery as to what they call standing. If you look at page 3 of some materials that I just handed to you, I will give you the actual questions given to me in a case dealing with a wife of an alleged drug dealer, wherein the questions that are propounded to this and deal with what's your Social Security number, what are the name of the employees and Social Security numbers of the employees that work for your restaurant, because in fact what they're attempting to do is intimidate the keeping of this money by challenging the concept of immigration. Here's the most shocking part to me, in having done this for a number of years now, and having done all of these cases for a period of years. Overwhelmingly, I represent mothers of people alleged to be drug dealers, and overwhelmingly, I represent relatives of people that have been alleged to have been drug dealers. And in fact, in that period of time, when I'm now working on some 35 cases, I can think of one person that was clearly convicted of being a drug dealer, and one that was kind of convicted of being a drug dealer. Over half of the cases that I've handled, I represent mothers of alleged drug dealers. And the process, unfortunately, because of the fact, in my experience, is that the local agencies are getting these sharing funds back to these specific agencies. I want to show you something from just last week. I gave you some documents on page 5, I believe. It's a property receipt issued just last week. And you'll see that it was issued by the Southern Alameda County Narcotic Enforcement Team, SACNET. This is a typical seizure notice that was issued in my experience in the state of California. The first thing you'll notice is that there's no address and there's no phone number as to who seized the money. If you look at the next page, this is a forfeiture notice issued out of Santa Clara County from a similar agency in November or December, I forget which. And you'll see there's a P.O. box and a phone number. That phone number, you'll see that someone scribbled out and wrote judge, is in fact not a phone number for Santa Clara County Specialized Law Enforcement. It's in fact a phone number, one of the random phone numbers for the Santa Clara County Superior Court. So when the funds are seized, the first thing that these people are dazzled with is the complete inability to even know who has seized their money or the ability to communicate with them. And what you see, if you look back to the page there, These are very small numbers, but this is unfortunately typical of what I see. If you look at the first seizure, it was for $840, and it says NW bedroom. Well, in fact, it was seized out of a bedroom. It was seized out of a 13-year-old's bedroom. It was her piggy bank money. If you look at the next item, you'll see U.S. currency, 1590, and it says different bedroom. In fact, that was removed from a person 18 years old, who had been 18 for 2 days, and it was taken from his wallet, and it was, in fact, his birthday money. Now, in this particular seizure, we're actually looking at over $200,000 in seizures, of which $175,000 is directly traceable to life insurance proceeds. So, and this is, and again, we're talking about uncle's monies, or in this case, also some brother's monies. It is the process as it's currently being run is that this money is typically seized with a process where they go into the homes of the alleged drug dealers, look for any kind of financial connection they can find to any kind of bank account, and then indiscriminately seize it. They typically have chase cars when they get to the locations, and then once they find any kind of checking documentation or account documentation, irrespective of whose name's on it, if it's mother's or the wives or anyone like that, then they proceed to send a chase car out to immediately lock that money up. And then the person is stretched into this process whereby particularly, and even worse, if it's referred to the federal government, I showed you the type of questions you asked, but then if you look further in the documentation I gave to you, what you'll see is that the first thing the federal government does is move to stay any and all discovery in the case for the person to attempt to get their money back. So what they'll do is they'll immediately run into the court after they first attempt to intimidate the person in any way they can in order to keep them from trying to take their funds back, assuming they can even figure out who it took, who in fact took it. And then what you'll see is the next thing they do is they go to court and they attempt to get an order issued where the person cannot find out why their money was even seized in the first place. And if you look in this particular case, and I'm going to give you this as an example, I called this woman over the weekend and got specific permission to talk about this with you. This was a 61-year-old woman who lived in Palo Alto.
I have to say, in 4 minutes, we're going to be called onto the floor.
Okay.
This will either have to be continued until 1:30 or 2 o'clock this afternoon, or we're going to have to
We'll wrap
take
it up
the
in 4
testimony
minutes.
more
Go
quickly.
ahead, Mr. Bax. 1 minute each, Mr. Bax and Mr. Thampy.
Good afternoon, Glenn Backus for the Drug Policy Alliance. Our simple point is that California laws should be followed by California agencies. As the attorney just mentioned, California has exemptions for family members who are guiltless. Family members don't lose their home and bank account for something someone else did. California laws are better at protecting the innocent than our federal laws. California laws require a conviction before your property is taken. That is not required in federal law. Even if a person is found not guilty, the onus is on the individual to come to court to try and get their property back. That's just not fair, and it's just not right.
Mr. Thampy?
Assistant U.S. Attorney Stephen Welk, an attorney for one of the southern federal districts, recently commissioned a survey of the 94 federal attorneys' offices about the use of the appointment of counsel provision passed in the federal 2000 Civil Asset Forfeiture Reform Act that allowed the government or allowed the claimant in these proceedings to petition for counsel. In the 11 years since this reform bill has been passed, this provision has been used between 11 and 15 times in the throughout the entirety of the United States. Over that period, civil forfeiture revenues at the federal level comprised between $13 and $15 billion. Last year's equitable sharing revenue for California law enforcement was $75 million. We know that we can estimate that the real amount of seizures that happened in 2010 from California was actually closer to $90 million because the Department of Justice keeps 20%. Thank you.
Affiliation to, I'm sorry.
I'm the Director of Americans for Forfeiture Reform.
Oh, thank you.
Madam Chairwoman Francisco Labaco, on behalf of the ACLU, we were here when we amended the forfeiture statute. This protects California property owners, and I may add that it actually may bring a little more money into the general fund. We support the bill.
Nate Bradley with the Law Enforcement Against Prohibition. We will echo everything they said, and we support this bill.
Thank you. Are there others in support? Are there speakers in opposition to the bill? No. Yeah, if everybody could come up, and again, we're going to have to go into session in a minute, so. Thank you. We'll begin. Mr. Lovell.
Good morning.
Good morning.
John Lovell with the California Police Chiefs Association and the California Narcotic Officers Association. I'm joined here by literally the entire law enforcement family. This is a bill that is designed to prevent local law enforcement from making lawful use of federal remedies. The very idea that a state can restrict the ability to make lawful use of federal remedies was discredited back in the 1950s when the segregationist South tried to prevent people from making use of the federal remedies that were offered. The fact is that federal drug asset forfeiture plays an important role in going after some of the most sophisticated and ruthless criminal enterprises. This bill is nothing more than a dagger aimed at effective law enforcement, and we would urge you to summarily reject this. And I'll give the rest of my time to people who have come here with specific expertise on the issue.
Thank you.
Good morning, Madam Chair and members. Lieutenant Barbara Ferguson, San Bernardino County Sheriff's Department. For reasons stated by Mr. Lovell, we are in opposition to this bill.
Madam Chair, members of the committee, Marla Marshall representing Sheriff Bill Gore in the San Diego County Sheriff's Department in strong opposition.
Good morning, Madam Chair, members. My name is Greg Totten. I'm the District Attorney of Ventura County, and I'm here today testifying in opposition to this bill on behalf of the California District Attorneys Association. In deference to time, I've provided each of you through your sergeant with a detailed statement setting out specific reasons for opposition, but there are 3 points I want to make. First of all, I was here in 1994 as the Executive Director of the California District Attorneys Association when AB 114 by then Assemblymember John Burton was adopted. That measure was debated. It received spirited debate. It built in a whole host of protections in state law. But there was a fundamental recognition by both Mr. Burton and the entire legislature that federal law was more broad, was different, had different procedures and different processes. And nobody sought to change that. It was recognized that we were focused on state law. Today, what is being done in AB 639 is an effort really indirectly to change federal law. And the fact of the matter is if you want to change federal law, the effort should be entered into in Congress, not in the halls of this legislature. This is an inappropriate place to do it. Secondly, I want to emphasize that the impact of asset forfeiture on drug interdiction and drug trafficking is huge. Asset forfeiture cases routinely that start off as very small seizures, a traffic stop where maybe $30,000 is found. Those small seizures often lead to huge investigations. In our case, we had a simple pharmacy that was writing fraudulent pharmacy requests and approving narcotics being distributed to people unlawfully. It started off as a very small investigation. It led to a multi-million-dollar operation that was multi-jurisdictional. If we had been forced to simply go by way of state law or do what this law requires and go into court and have an evidentiary hearing where we're challenged on the investigation, our investigation would have been compromised. Countless individuals would have been supplied with dangerous narcotics, many of which, in the case of OxyContin, have produced mass deaths across the state and across the nation. This proposal is, as Mr. Lovell said, a dagger in one of the most valuable tools that we have in law enforcement to protect our children from dangerous narcotics. We have administered the law very responsibly. I don't hear, frankly, and I don't accept the so-called abuses that were cited by defense counsel. They just don't exist. We use federal law sparingly. In Ventura County, only about 10% of our cases involve federal adoptions, and there are solid reasons related to our federal, state, local task forces. This is a bad bill that will harm law enforcement. The biggest losers in this are going to be the taxpayers, because it will not, I guarantee you, it will not produce more revenue for the state general fund. If anything, it will weaken that revenue. And most significantly, it will increase the distribution of dangerous narcotics in California, and it will take law enforcement and tie our arms behind our back in fighting that battle. I strongly, strongly urge this committee to kill this bill. It is a bad bill.
Others in support? In opposition?
Good afternoon, Madam Chair. Curtis Hill, the State Sheriff's Association. We also join our law enforcement partners in strongly opposing this bill. Just on the natural going in, we estimate it'll cause a $2 million loss of revenue to law enforcement, and even that number is we feel underrepresented. One of the additional issues caused by this bill is that it places the judge in a position of making operational decisions relative to a narcotics investigation. You have to understand that narcotics investigations and the use of the federal government is an overall partnership. In my history, we used the federal government sparingly. However, we did use it with force and the power that came behind it when it came to enforcing trafficking with mid and major drug traffickers. The Mexican cartels are coming across our border as we speak. They're becoming stronger and stronger. Not being able to utilize our federal partners in these matters without going to an evidentiary hearing prior to the enforcement action is problematic. In addition, we feel that AB 639 will place the Attorney General's office in the ostensible position of being a policing agency over state asset forfeiture. On the one hand, we're working in partnership at the local level with the Department of Justice and the AG in these investigations. And then on the other hand, they're going to be in an adversarial relationship by policing this process, which is spelled out in the bill. We strongly oppose it on behalf of the State Sheriff's Association. Thank you.
Thank you. Others?
Madam Chair, members, Dan Filizotto on behalf of the Los Angeles County District Attorney's Office. I echo the comments of my colleagues. The one thing I do want to stress that this bill arguably does that would be a significant change in current law is that under this bill, the moment assets are taken into custody or possession by law enforcement, they would be deemed seized for purposes of California law. Now, when law enforcement takes possession of assets, a lot of cases, law enforcement uses a small window to determine whether or not those assets are forfeitable. Under this bill, they will be deemed seized the moment they take law enforcement takes possession. I don't think that's the author's intent, but as drafted, that's what AB 639 would do, and I don't think that is in anybody's best interest.
Jennifer Wada with the California Peace Officers Association, opposed for the reasons stated.
Thank you. Assemblyman Norby, would you like to respond?
Well, I think some of the opponents have
raised?
summarized my summation better than I can, talking about the loss of money, talking about this bill will not lead to more funds, more revenue. This bill isn't about revenue. In fact, the abuses are about revenue. The city of Bell is losing money now because they can no longer seize cars that they routinely seized in asset seizure raids on motorists who didn't have proper documentation or there's immigration or insurance that they routinely did to finance operations. When we're funding operations based on asset seizures, that is the wrong path to take. This bill is about protecting liberties. We celebrated the 4th of July last year, or just yesterday again. We'll celebrate it again next year, and we celebrated it last year. And when you look at the Bill of Rights, when you look at the Declaration of Independence, it talks about life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men. It says nothing about expanding police powers. It says nothing about wars on drugs and other expanded police powers. It talks about limiting the power of law enforcement to focus on those who are violating the laws, not creating a vast net that catches lots of people in who lose their property and can't get it back. That's my summation. I ask for an aye vote.
Thank you. Are there comments or questions from members of the committee? Seeing and hearing none, is there a motion on the bill?
I move the bill.
The bill's been moved by Senator Anderson. Madam Secretary, please open the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Calderon? Harmon?
No.
Harmon, no. Lou? Price? Steinberg?
Your bill is on call.
Thank you. Thank you, Madam Chair.
The committee will now recess until 1:30 this afternoon, when we'll reconvene in room 2040.